are gathered here today because the state of California has found that Marvin Miller, the defendant, was found in violation of a California state statute that describes the illegal manner of mailing, possessing, distributing, selling, and publishing obscene material, Section 313.11. The defender was charged in the state of California for mailing out explicit photos and drawings on 5 different brochures that were used to advertise his adult books. Seen on the brochures were multiple nude men and women engaging in sexual activities like group sex. Residents in Newport, California, notified authorities, and Marvin Miller was arrested, charged, and convicted for mailing unsolicited obscene material to individuals without their consent. Obscene materials are not protected by the First Amendment, and the high courts have reaffirmed this provision with the use of an obscenity test created after Roth versus the United States in 1955. In today's proceeding, we will discuss the Roth standards of measuring obscenity and how Mr. Miller violated that federal standard. The state of California holds the right to convict Mr. Miller under California's statute of obscenity.
The Roth versus United States case, which took place in 1957, remains our basis for the definition of obscenity. The court also created standards, which now will be recited. Number 1. Community standards should not be violated under any circumstances. In relation to this case, standards were violated as the community of Newport Beach, as well as Orange County and other several neighboring counties, received unsolicited flyers containing explicit photographs. These documents were received unwillingly, as no one who received them had asked for them or known that such explicit material would be revealed once opened. This standard we hold to be true, and therefore, Miller's actions are unacceptable. In the initial Roth case, the court mentioned the idea of community. Regardless of the dictionary definition of the word, the footnote 2 to Jacob Ellis implies that the customary definition of the word community is the place in which people work, live, shop, and entertain themselves. This definition is contemporary, and therefore, constitutionally, we can accept this idea of a community standard. It is indeed more contemporary, and therefore can be applied more to the ideas of obscenity compared to the phrasing of 1791 when the First Amendment was embraced and legally included. This task to update the community standards and keep them contemporary may require updating and readjustment as time goes on, but this is a doable task for the well-being of people, the country, and their communities when it is being accomplished now. The second standard of the Roth case stated that there is no literary or artistic value to be found in obscene content. In this case of Miller versus California, we believe there to be no element of such in Miller's unsolicited advertisements. Thirdly, obscene content does not and should not appeal to prurient interest. It is likely in this case that such flyers as the ones that Miller sent out do indeed appeal to prurient interest, thus making them obscene for those not of prurient interest who otherwise follow community standards. Fourthly, sexual offense must exist in the content in order for it to be perceived as obscene, and in the case of Miller, the sexual content including taboo subjects, such as group sex, do indeed fall under this category. Lastly, the overall theme of the subject must be questionable to be obscenity. There is no doubt of the obscenity in the sexual materials that Miller sent out, as there were 5 brochures sent out to a variety and range of people, which all included visceral depictions of explicit sexual activities. Therefore, as Miller's mail subjects all related to each aspect of the Roth case relating to and defining obscenity, it is clear that he has indeed taken part in an illegal sharing of obscene content.
Firstly, we'd like to say thank you for hearing our case. To begin our summary, we'd like to say that the state of California believes that Mr. Miller was in violation of not only California state law, but of federal law as well. Hopefully, through the explanation of our case against Mr. Miller, you're able to see just how his actions are obscene and should not be allowed. We've stated how his actions of sending those graphic flyers depicting pornographic imagery through the mail were against community standards as well as the standards set by the Roth versus U.S. case. We established that there was no inherent artistic value and that there is no doubt that the material in question is indeed obscene. After hearing our case, we hope that you will side with the state of California in your decision. Thank you again for your time.
Mr. Chief Justice, may it please the court, the purpose of my argument today is to express the proposition that the court has not become acquainted with the realities of the situation which lawyers and perhaps judges are faced with when approaching an obscenity case when it is put into the criminal context. The first proposition I have is that there is a new reconcilable conflict between the decisions of this court, irreconcilable in the sense that they are logically inconsistent. I'm talking about certain cases of obscenity, Roth versus U.S., Stanley versus Georgia, and Rydell versus U.S. The second proposition I will be making today is that this court has vocalized the assumption that lower courts and lower judges, both state and federal, will obey the mandates of this court when it comes to deciding on an obscenity case. When you are dealing with obscenity or pornography, that, for the most part, is a visceral turnoff to the majority of the courts in which you go in front of. Mr. Miller, the defendant, is president of a corporation which sends out advertising brochures. The sender of the brochure was Covina, located in the county of Los Angeles. In the county of Orange, the neighboring county, a prosecution was commenced in addition to this prosecution for violation of Section 311.2 for the brochures which are illustrated of history of pornography, sex orgies illustrated in the book entitled Man/Woman. The exhibits in this case were described in the opinion of Judge Arguelles in Los Angeles Municipal Court. He described that there were pictures of cunnilingus or oral copulation, sodomy, and oral intercourse between a man and woman. The fact that these particular images are drawings seem to be irrelevant since it becomes a jury's job to determine under certain rules laid down whether or not they are obscene or not obscene. And also the job of apparent experts to determine whether the average non-consenting adult looking at these pictures as they come to them through the mail will have an immediate appeal to his prurient interest. Because of this exhibition, it doesn't seem to follow. There doesn't seem to be much empirical evidence, and I have a red light.
Argument number 1, Roth versus U.S. Roth should be clarified because in Roth, and I'm paraphrasing this, the court said that obscenity is not speech. Yet in Stanley v. Georgia, the court said that obscenity is speech. Then in Rydell versus U.S., the court said that they adopted both Roth and Stanley, and they don't vary in one way or another. So we then come to an unusual proposition that speech is not speech. Argument number 2, theory of constitutional protection. It appears from reading these other cases that if you have First Amendment protection and you add on, for instance in the Stanley v. Georgia case, Ninth Amendment protection, the right to privacy, 1 and 9 equal 14, and you have constitutional protection. In this case, we have a few other add-on protections that Mr. Miller should avail himself. He has First Amendment protection as well as Fifth Amendment protection, not having to testify himself and if committing a crime, and Ninth Amendment protection, which is again privacy. So with the protection of 1, 5, 9, and including 14 equal protection to the law, he should have reversal, the decision of a court of appeal ruling that in this case, the lower court was incorrect.
Argument 4, national standards. We must have national standards in the area of film. Otherwise, state aid can impose unreasonable burdens upon what kind of films are shown in the motion picture theaters in their neighborhood. Perhaps one community or state doesn't like rated R films because rated R films portray sex in them. Some X films often have more violence and less sex than rated R films. It depends upon the individual's idea of censorship. I am suggesting a process whereby, if there is probable cause to believe that a material is being sent out or sold, is or may be violative of the penal statute, or may be obscene within the area of the state statute, that the judge issues a show cause order and perhaps even a seizure warrant. The material is seized, it is brought into court, there's a 1-day hearing, an expert testimony, and 2 days to make a decision. The decision should be in writing, stating the judge's reason for believing that the material is or is not protected. At that point, you have some sort of adjudication because the real proposition and problem is with Mr. Miller and every other seller of pornography has a justice in this case. Argument 3, local versus national protection. We need guidance from the court, this court, and I don't think it can be done in the framework of deciding whether national or local standards apply because the courts below us don't know how to apply them. They work on a case-by-case basis, so we must be set up with some rules and guidance.
In summary, after going through the various cases and the paradoxes arisen by the decisions of the appellate courts, there is no answer other than to set a new standard. You can't resolve the decisions of this court and the various justices, and the only resolution is to take everything and say, okay, that is the way it is. Speech is not speech if it is obscenity, and then set up a set of rules so that the judges will know exactly what to do when they get placed with an obscenity case. I would say bar the criminal prosecution. Take it out of the criminal area until you have a prior hearing as to the obscenity or non-obscenity of it. Thank you, Justice.